Please be seated. 3 cases are being submitted today. The third is non-oral, State of Iowa versus Ewan Connor Gardner Jr. That case is now submitted, and the court will hear oral argument in the estate of Philip Raymond Morgan versus Union Pacific Railroad. Mr. Slocomb, are you ready to proceed?
May it please the court. My name is Paul Slocomb, and along with George Davidson, we represent the estate of Philip Morgan. This case was accepted by this court under 3 different sections, one of first impression, one of fundamental or urgent issues, and the other enunciating or changing legal principles. I had to guess at perhaps which one we were talking about, but I think it, and I'm hoping it is changing legal principles. This is an FELA case. As the court knows, the FELA is a broad remedial statute, and in certain respects, it is an avowed departure from the common law. With that said, the FELA creates a body of federal common law that is informed by the evolving common law. And that's, I believe, what we are here for today. Under the FELA, we have brought a claim for death, in using the statute, resulting in whole or in part from the negligence of officers, agents, and employees of the railroad. And to start with FELA, we start with McBride. McBride is a 2010 U.S. Supreme Court case which reaffirms many of the principles that were laid down in the Rogers versus Missouri Pacific case back in the 40s. Importantly, I think crucially for this case, under McBride, the FELA's in whole or in part language is straightforward. Reasonable foreseeability of harm is an essential ingredient of negligence. If negligence is proved, however, and is shown to play any part, even the slightest, then it doesn't matter if the injury is unforeseeable. That's what McBride says in 2010. And I think that's a good touchstone for dealing with this particular case. Briefly about Phil, the deceased. He would have been 55 this year. Phil was devoted. He was devoted to his country through his service through the U.S. Navy. He was devoted family man to his wife, Kira. He was devoted as a father to 4 children. And he was devoted to his employer of 20 years, the Union Pacific Railroad Company. He was a welder helper, and as our brief indicates, all of the work done by a welder is done in the red zone. The red zone is a location of imminent and ongoing danger. It is on the tracks. All of their work is done on the tracks.
And if any work is in the red zone, are we to assume then that it is within the zone of danger that the cases talk about?
I think it requires more analysis than that, and I can cut straight to the point on that. On Gottschall, the Gottschall court remanded Mr. Gottschall's claim to the Third Circuit, or ultimately to the district court, to determine that exact issue of, okay, you're in the zone of danger, but is it imminent danger? And what the Third Circuit says is, Mr. Gottschall, you lose, you're not in the zone of danger. And the reason in Gottschall Third Circuit after remand is they're saying that simply doing your work in the red zone without any added dangers is not being within the zone of danger of the Gottschall test. There has to be something more. And we believe that we have given that something more. This isn't a matter of somebody just going out and working in the red zone, which is a place of danger at all times. This is a person who has been sleep deprived, has had a couple hours of sleep. He is not being alert and attentive out on the tracks, and that creates the risk of immediate harm. But our position is deeper than that. We don't believe the Gottschall test applies here. And quite frankly, the reason is Gottschall, the touchstone of Gottschall, first was, is this an emotional injury? And so Godshall, the U.S. Supreme Court said, okay, we're dealing with an emotional injury. And let's look at whether we should recognize that under the FELA. And they did ultimately recognize it with several caveats. The caveats were based on three primary policy considerations, which we believe are absent in a suicide case. The policy considerations considered by Godshall dealt with, are we going to have trivial, claims? Are we going to have a floodgates of litigation? Are we going to have difficulty with problems of proof? And so the court in 1993 was leery of those kind of things, like, oh, I'm depressed, or if anybody has a teenager, I'm sad. What does that mean? And so the court in Godshall rightfully said that that's an issue, and we have to create guardrails so that we don't have floodgates of litigation. I'm not here asking you to overturn, you can't overturn Godshall, obviously. I'm not asking you to apply Godshall somehow differently. I'm saying that a suicide is not an emotional injury. It's a physical injury. Yes, ma'am.
There was a companion case, Carlisle, I believe, and in that case, the Supreme Court said that they were not going to uphold what they called an unprecedented holding that would impose a duty to avoid creating a stressful work environment. Can you address the Carlisle part of Godshall?
Your Honor, the Carlisle case is interesting. The Carlisle employee was someone who worked in the dispatch center, almost akin to an air traffic controller. And in the Godshall case where they address Carlisle, they simply say, too stressful work or too much work is not cognizable under the FELA. That's not what we're saying here. We're not saying that Phil Morgan was given a job that every other welder was given and, he just couldn't handle the job as it's presented. That isn't what we have here. We have additional factors of negligence that created an unsafe workplace for Mr. Morgan.
Expand on that a little bit. Is the negligence, I understood it to be basically his relationship with the supervisor. His supervisor just pushed him too much and created a stressful environment.
But it was the underpinnings for why he created that stress. It was dealing with the shorthanded nature of their ranks. They were shorthanded on welders. So we have this catch-22 where we don't have enough welders and they're pushing for more and more production. That's what creates the unsafe work environment. That's what triggered my client into the stressful situation where he's having symptoms of sleeplessness, anxiety, and that's the reason that he went to have this treated.
Describing Mr. Slocomb, that sounds sort of, that would go to fault or negligence, but still, the case strikes me fundamentally, obviously, different on the facts, but we're bound by the law of Godshall and not just the facts. And doesn't Godshall say that if you have a situation where an individual is suffering workplace stress, even high workplace stress, and then that emotional injury has physical consequences? I think in the Carlisle part, it was loss of sleep, depression, loss of weight. There were the insomnia, there were physical consequences. Obviously, the individual did not take his own life, but doesn't this fit under that Carlisle pattern, this case?
Number one, even if you assume a suicide fits within the zone of danger test, we have negligently created stress. That didn't happen in Godshall. Godshall and Carlisle did not deal with things that would be considered negligent. They made that my work was too stressful. Then, I hate to say it, but then go get another job. But if you are given a job and then you have additional factors like a supervisor that creates a negligent or unsafe workplace, that is the difference between our case.
Part of the case, the facts seem pretty egregious. Like there was an individual who was collapsing, wasn't getting water. He turned over and died, and they left his body out there. And then Godshall saw that and suffered emotional stress from that. So that sounded like, not say suboptimal employer behavior, but even there, the court. In the end, the Third Circuit ruled that there was no claim.
To see a coworker die in that manner, but how? There was no allegation that negligence was, that there was negligence of the railroad that caused Gottschall the injury. That wasn't in the case.
Making them finish the shift after somebody had died right in front of them, that doesn't sound like very good employer behavior.
I agree.
Was negligent infliction of emotional distress. I mean, there was, just as an element of the claim, there was necessary proof of negligence of some sort.
There is, and again, but what we're saying is that
Push it because there wasn't in that case, but there was.
wasn't. Gottschall, in the Third Circuit, they ended up saying that there wasn't, they said there wasn't any negligence. When it got remanded back to the Third Circuit, that's what they indicated.
They still created the zone of danger test or physical impact test in a negligence case.
Injury.
That's kind of your bigger distinction is,
Because again, you know, if going back to the three policy considerations, how does that apply to a suicide? The policy underpinnings of Gottschall make no sense. We don't have,
The policy regarding proof, are there challenges in determining causation on a suicide, or recap the facts that get you there in this case?
there will be there will be causation issues, but it's causation issues under the lens of McBride, which I started with in terms of the foreseeability issue. But on causation, we had an expert report that flat out said this was a result of the harassment and the intimidation. And I would say this, it's interesting, the Gottschall Third Circuit case that preceded the U.S. Supreme Court case has a really interesting discussion about, you know, yeah, we get why we've got to create a test, but they did mention, hey, look, science has come a long way on mental issues. And I was thinking about this morning. I've done FELA work for 35 years. Most of my work is back injuries and things like that. And, well, isn't that a subjective complaint? Isn't it within that person's ability to fake this? And with what we know now about mental disease and mental injury, we're asking that it's time to move on. And quite frankly, back to 1993, to the Kostelek decision by this court.
Can you address, if we agree with you that the zone of danger is not the proper test, even then there's a suicide rule. Can you address how you get past that?
Like, you were right in Kostelek. And again,
We're applying federal law, but you say that we should apply that.
the Ayers decision, the U.S. Supreme Court says that federal common law is created by evolving common law, and that includes from this court. And so, you know, the delirium frenzy thing, your sister court just south of us where I'm from in Missouri, the Kivlin case, you know, they said, well, the defendant in that case said, well, you haven't even you don't even have an expert that says he's insane. And as the court pointed out, go to DSM-4. It doesn't, insanity is not it's a legal term. And it's a term bandied about that doesn't make any sense. And if you look at the line of the suicide rule and the insanity delirium defenses or exceptions, they go all sorts of different ways. Like in the Kostelek case, this court found, well, just because he was calm the night before doesn't mean boo, really, about causation, does it? Other cases say, well, he was calm, he didn't seem crazy, so we're not going to cover him under the rule. What we have in this case is undisputed notice evidence like I've never seen before. Coworkers, union representatives, not only going to the offending supervisor, but going to that person's supervisor. We have the medical record from before he committed suicide. The causation here is clear, quite frankly. So we think for those reasons that this ought to be considered, and what we ought to do is treat this, the ruling I'm asking for is say this is a physical injury, and we're going to use the traditional FELA duty breach cause damage. And we have experts that can sift through those things and delete and get rid of the unmeritorious claims. But the idea that the broad humanitarian purpose of the FLA doesn't include a suicide because they didn't happen to be in imminent physical danger, I mean, it doesn't,
You limit this new rule to suicide, or would it, you wouldn't? So we're not opening the door to a variety of other insomnia, that type of.
you to do that. I don't think that, certainly this record's not developed for that, and I'm not seeking that. And I see the merit to some degree of Godshall when you're dealing with someone who's sad or has anxiety. You know, who knows? You know, I may be sad right now and nobody could tell us that. But suicide, you can't fake. You can't bring it back. And none of the policy underpinnings for Godshall make any sense in light of suicide. Thank you.
May it please the court, John Amarillo for Defendant Union Pacific Railroad Company. The issue before you today is at its heart one of statutory interpretation. And as we all know, when we're faced with an issue of statutory interpretation, construction, legislative intent is the key to everything. The U.S. Supreme Court explained text as it reveals intent. Yes, Your Honor. The U.S. Supreme Court explained in the Godshall decision that Congress's purpose, its focus in enacting FILA was to provide a remedy for workers injured by the physical dangers of railroading. This is something that I think gets lost in plaintiff's argument quite a bit. Mr. Morgan was not killed by a physical danger of railroading. He was not hit by a train. He didn't fall into a maintenance pit. He didn't suffer chemical exposure and some long latent disease. He took his own life at home. A tragedy, surely, but simply not something covered by the FVLA. Because if Mr. Morgan wasn't killed by a physical injury at work, then plaintiff's only avenue for relief is to say that he suffered an emotional injury at work. And Godshall says there's two categories of such emotional injuries. The first is an emotional injury that stems from a physical injury, your everyday pain and suffering. No one thinks this is that case. The second is a standalone emotional distress claim. And as Godshall made clear, and then I think importantly affirmed in cases like Metro North and Ayers, this second category of recovery is sharply circumscribed, their word, sharply circumscribed by the zone of danger test. There is no third category of recovery under FILA, which is what plaintiff is asking you to create. He began his argument by saying that he is asking you to change legal principles in light of binding U.S. Supreme Court precedent to create a new category of essentially emotional injuries that have physical consequences, call them symptoms, manifestations, harms, injuries, whatever you want to call them. That is what plaintiff is asking you to do. The problem there is that federal courts have already addressed and rejected that very same argument, which is something plaintiff simply doesn't acknowledge in his arguments or his briefing. Now, my brother counsel argues otherwise. From what I just heard, he's essentially arguing the following syllogism. Mr. Morgan sustained a physical injury, death. That wouldn't have happened but for the conduct of his supervisor. Because McBride says that any injury caused in whole or in part by a railroad's negligence is compensable, Mr. Morgan's suicide is compensable. That's plaintiff's argument in a nutshell. That is a false syllogism. Plaintiff is asking you to ignore the nature of Union Pacific's alleged conduct, ignore the nature of the injury that Mr. Morgan supposedly suffered as a direct consequence of that conduct, and ignore, again, binding U.S. Supreme Court precedent on how to handle workplace stress and workplace harassment claims. I don't see how that works given what the U.S. Supreme Court and the federal reviewing courts have told us about how to handle workplace stress and harassment claims. Those courts say you have to look at the nature of the alleged injury, the nature of the alleged conduct, and you do not look at how plaintiff is labeling that conduct, which is precisely what my brother counsel just argued against a moment ago. Here,
Syllogism was false. you said it was false, but then I'm not sure that, his misreading of the case or alleged misreading of the case makes that false. What do you think is wrong? And I guess let me also ask a secondary question. The text of the statute, not the purpose as indicated by the Supreme Court, says that he's entitled to compensation for injury or death. And I think his point is Gottschall is about what kind of injuries qualify, emotional injury in that case. And he just says that's not an injury case. This is a death case. Why is that wrong?
Because you're not going to find any federal reviewing court or especially Supreme Court authority classifying an injury like this as a physical injury. It is an emotional injury under...
Classified as a physical injury. I mean, he is dead, correct? And the statute says that they can recover in the case of death, not injury, death. Yes. So why are we talking about injury?
Section 51 of FELA doesn't distinguish between personal injury or death. They're phrased in the disjunctive. There's only one claim. It's negligence for physical injury or death. This distinction that plaintiff is asking you to draw finds no authority whatsoever, or finds no support, rather, whatsoever in federal authority. And I think that is part of the key difference that the plaintiffs are arguing about here. Nothing, what cases, I'm sorry, Your Honor, I'm not aware of any that he cites. I'd be happy to go through them individually.
Let's see. Weren't there a bunch of district court cases that provided jury instructions on suicide cases? And I mean, you say he doesn't cite any. He seems to cite like 4 or 5 different ones. And I understand you think they're distinguishable or they're pre-Gottschall, but it's not like they're not out there.
3 cases. I understand the ones you're referring to now, Your Honor. There's the Nelson case, which is a appellate court case from Florida. There's the Halco case, which I'd like to dive into, and then there's the DeLeese case. The Halco case supports our position on this very point. That was another supervisor harassment and suicide case, pre-Gottschall, as you point out, so it didn't have the benefit of the Supreme Court's guidance in Gottschall. How did the court describe and classify plaintiff's claim there? Again, this was a suicide case, as you pointed out, Justice McDonald. And if I may, I'd just like to read 2 sentences. I don't like doing that, but I think it's particularly poignant here. This is the court. The complaint herein alleges that Halco's death by suicide was the result of torment to which he was subjected while an employee of Conrail. Essentially, this is a claim for negligent infliction of emotional distress leading to suicide. Negligent infliction of emotional distress. What governs that? Gottschall. Plaintiff can't escape that fact, no matter how he labels this as a physical injury or as an emotional injury. Now, plaintiff says that all that authority that we cite, Gottschall, Crown, Smith, is inapplicable because it wasn't a physical injury or death or suicide case. That's simply wrong on the facts. I know this court is very familiar with the case law from its questioning. Gottschall, there were absolutely physical harms that were alleged: nausea, insomnia, cold sweats, weight loss. In Smith, the 10th Circuit decision that we rely on, they talked about physical injuries resulting from the emotional injuries. There it was insomnia, anxiety attacks, exacerbation of a spinal injury.
Wasn't DeLeese post-Gottschall?
Was post-Gottschall. That's a district court out of Connecticut, Your Honor. I think that case can be distinguished and essentially put aside for 2 reasons. One, the Falk decision from the Middle District of North Carolina that we cite that came afterward, accurately said that DeLeese didn't consider the Gottschall framework. I think the issue simply wasn't teed up properly for that court by the parties. And 2, if you look at DeLeese, there's no analysis in the FELA section. It essentially reads like a summary order. To borrow a famous line from Gertrude Stein, there's just simply no there there.
Discuss Gottschall?
It doesn't, Your Honor. In all of the cases that we cite, the courts applied the zone of danger test because they realized that an injury allegedly caused by the railroad, even in suicide cases, was an emotional injury at its heart. So even when there are physical manifestations, again, injuries, harms, whatever you want to call them, it's really an emotional injury that we're talking about here, which raises the question, and this came up during your questioning, if plaintiff's view is adopted, what do we make of those cases? Which is another way of saying, where's the limiting principle? And there simply is none. This doctrine that plaintiff is asking for cannot be limited by its very nature to suicide cases. What about attempted suicide? Why wouldn't plaintiff's logic apply there? What about other self-harming behaviors like cutting or an eating disorder or substance abuse? Why wouldn't plaintiff's logic apply there? It would. There's simply no line that can be drawn around the kind of decision the plaintiff is asking you.
I guess Justice Thomas says this in Gottschall, that if you just read the FELA language by itself in isolation, it's pretty broad, injury or death. And what you're saying is injury or death doesn't include a physical injury or death that is sort of an outcropping of a workplace emotional injury. Is that essentially what you're saying?
If I understand your question correctly, it is, Your Honor. Yes. Folk v. Northern, or
in the analysis that Gottschall seems to be the traditional kind of negligent infliction of emotional distress bystander claim, right? The plaintiff in that case witnessed somebody else have a heart attack, I think, if that's right, and that caused distress. This is more of a direct emotional distress claim where, at least as I understand the record here, he's alleging that his supervisor was kind of targeting him and putting extra pressure on him. Does that matter?
does. I would resist the characterization of Gottschall as purely a bystander claim. He was complaining about the working conditions, like the plaintiff does here. It was too hot, they were working too long, they were being asked to do too much, in addition to seeing his friend die right next to him and being asked to ignore the body for several hours.
There was Carlisle, yeah.
That was just a general stress of the job kind of case. I think fault goes to your question, Justice McDonald. That is, again, a suicide case stemming from workplace harassment, very familiar to this one. The full court said no matter how plaintiff framed the issue, no matter how he labeled it, suicide cannot be used as an end around the zone of danger test. And the full court held that workplace harassment standing alone simply doesn't satisfy that test. And let's be very clear about something. Folk is not an orphan. There are many cases supporting Folk on that very same issue. Roberts v. CSX out of the Northern District of Indiana, Gallimore Wright versus Long Island out of the Southern District of New York, the same district that decided Halco and then later decided it was wrong. Ferguson v. CSX out of the Eastern District of Pennsylvania, all that is in line with the authority that we cite, explaining that even severe mental or emotional injuries, even those that lead to physical harms, even those that lead to suicide, is simply not compensable because the zone of danger test applies. I want to be
make that they were required to work in a tent sort of on a live track or next to a live track, and that is within the zone of danger, and that would qualify.
I don't know what to make of that argument because we have no facts supporting it. All we have is inadmissible hearsay from the plaintiff saying that this happened at some point in the 20 years that Mr. Morgan worked at the railroad. I don't think that's enough of a hook for them to hang any kind of hat on, Your Honor. I just don't see it.
Or to find that there was sufficient evidence in the record at this stage, would the case live on?
So the argument would be that because at some point he may have had a near miss?
As an evidentiary matter, that we don't think that it's hearsay. We think that there's enough to sort of establish it for summary judgment purposes. Would that be enough?
To satisfy the zone of danger test if there was an actual near miss? If there was an actual near miss and they could point to something other than this statement that this may have happened at some point in the last 20 years, I think that could be enough. And I want to be, you anticipated my next point, I think, perfectly, Justice McDermott. We're not saying that suicide is never compensable under FELA. If, for example, Mr. Morgan had a near miss at work shortly before his suicide, and that's important because Gottschall and all of its progeny say that this has to be within a reasonable time, an imminent danger of the suicide. If he had suffered such a near miss, developed PTSD, gone home, and taken his life, that would fall within the zone of danger test, I believe. So we're not asking for a broad rule against suicide. What we're asking for is a very clear rule of law, which I think contrasts with what plaintiff is asking for.
would it need to be?
That could be a jury question. I think it would have to be within a reasonable amount of time. There's no authority delineating that, but if it was 20 years ago, 10 years ago, maybe a year ago, you're getting closer to the right zone. I don't know, but we don't have anything in the record, and this is summary judgment, so plaintiff had a burden here to carry to rebut. We don't have anything in the record on that.
Kind of reading the record that the emotional stress was tied to demands from the supervisor and not to this near miss whenever it happened at whatever point in time.
You're right, Your Honor, and that's another major problem with their argument. Their whole red zone argument and that their argument, actually, they don't have the argument. We tried to get ahead of it in our brief, and they never closed the loop on it, about this incident that supposedly happened sometime in the next 20 years. It's not linked to the negligence that they're complaining of, and they never link it up.
What do you make of Mr. Slocomb's argument that if you read Gottschall for what it is, it's the court kind of taking a broad reading of injury as including something other than non-physical injury, but also concerned, as they should have been in a kind of a common law statute, about the policy implications, and then trying to draw some limiting principles to narrow the scope of potential liability for railroads. That seems to make some sense to me, and it seems like your concession that there are some suicides that could be compensable is kind of along the same lines, right? That you could broaden it a little bit. So why isn't he right that those policy concerns don't apply in the case of suicide?
Time, if I may. The factual underpinnings of plaintiff's policy arguments are problematic for two reasons. One, they don't find any factual support in the record. He's just saying it. Let me give you an example. He says that suicide is rare. According to the CDC, suicide is the leading cause of death in about half the states. It's a top 10 cause of death in Iowa. Suicide is not rare. So his argument that the floodgates won't open because if the court recognizes suicide exception for the first time, that's contradicted by the CDC's website. His other argument that liability is limited because this is a FELA case and we're only dealing with railroad workers, that exact same argument, Justice McDonald, was raised by the plaintiff in Gottschall and rejected by Justice Thomas and the rest of the court. It's the exact same argument. Plaintiff can disagree with the Supreme Court's policy determinations on that point, but they're still binding. If there are no more questions, thank you.
If I may, I'd like to clear up a couple things on the hearsay argument about the tents. On page 16 of our brief, we reference a statement of Ron Christensen that deals with the high winds in the tents. So that's not just someone speculating on that. That's someone actually out in the field doing that work. I couldn't find the Third Circuit handy on the first go-through. On Gottschall, the Third Circuit, the U.S. Supreme Court remanded Mr. Gottschall's case back to the district court. The district court found that there was the zone of danger test was not met. The Third Circuit then dealt with that issue. And the Third Circuit says, while it was extremely hot that afternoon in north central Pennsylvania, it was still, for purposes of the zone of danger test, within the bounds of conditions under which Conrail crews were expected to work. Indeed, Gottschall does not contend that the conditions under which he was working violated any work rules. That's the difference. We have alleged that. They have a rule out there that says you must be alert and attentive at all times. The harassment and intimidation caused Phil Morgan to have a sleep disorder where he's getting 2 to 4 hours of sleep and then meant to go out on the tracks, which is a place of inherent danger. And that is why those issues are distinguishable. I do want to briefly mention, it's interesting, Gottschall, the U.S. Supreme Court, read into the word injury what its predecessor courts did not. The Urey versus Thompson case in 1949 flat out said, the wording of the FELA was not restricted as to the particular kind of injury resulting. Now, I realize the Gottschall court is kind of departed from Urey v. Thompson, but I think looking at the suicide cases is instructive. It is true that there were a number of suicide cases on the books, including the non-Effulé Kostelet case at the time the U.S. Supreme Court decided Gottschall. Gottschall, the U.S. Supreme Court didn't address a single suicide case in its analysis, not a single one, when there were multiple Effulé suicide cases on the books. So to say that the Gottschall court contemplated suicide, I think, belies the quality of the attorneys handling the case back then. The reality is these cases were on the books. Gottschall didn't address them because suicide's a death. It's a death case, and that's why Gottschall didn't address it. Same thing with Delise. Delise was decided after Gottschall. It didn't address Gottschall because Gottschall didn't apply to a suicide case. The cases they cite in support, I do need to speak specifically to the Folk case, because really the trial court in our case basically said, we have this Folk case, it's an Effulé suicide case, it considers Gottschall, it adopts Gottschall, I'm bound by Gottschall. That's how the district court came to that opinion. In Folk, it's interesting because it was on a motion to dismiss stage that case got dismissed. In a footnote 4 of the Folk decision, apparently the plaintiff's counsel brought up the insanity restatement exception to the suicide rule. And the Folk court specifically said, we're not addressing that. We're not going to deal with that. And then it says in another footnote, we don't, in Folk, they say, we don't rule out the possibility that suicide may be compensable. And they give an example of somebody getting run over by a rail car and then later committing suicide. Well, that's compensable every day of the week and has been before Gottschall. That example, it doesn't even apply to Gottschall. It predates Gottschall because that deals with physical injury, pain, and suffering after it. But what's interesting in Folk, I think, is they looked at the four corners of the complaint, which had words such as mental injury, instability, incapacity, emotional collapse, and breakdown. And then without any analysis at all, they say, well, that's not insanity. I don't know what any of those words mean. DSM-4 doesn't define those words, but the Folk court on a motion to dismiss basis just decides that that's not going to fit within the irresistible impulse doctrine that, by the way, in the previous footnote, they said they're not even going to address. So we think that Folk is not controlling, obviously, on this court. The analysis is faulty. So for those reasons, we think that the better reasoned cases, and really the Gottschall case, the Third Circuit before it got to the U.S. Supreme Court, they had it right. Duty breach, cause damage. It's a physical, this is a death case. And so for those reasons, we respectfully request that this court reverse the decision of the lower court.
The Gottschall, or excuse me, the estate of Raymond Morgan versus Union Pacific Railroad is now submitted, and the court will pause while counsel switch out for the next oral argument.